Good afternoon, everyone. Good afternoon. I'm Professor Victoria Shannon, and I am delighted to be introducing our Martin Luther King Jr. Day keynote speaker, my friend and mentor, Professor Kenneth Mack. Kenneth Mack is the inaugural Lawrence D. Beale Professor of Law at Harvard University and the co-faculty leader of the Harvard Law School program on law and history. His research and writing have focused on the legal and constitutional history of American race relations. His 2012 book, Representing Race, The Creation of the Civil Rights Lawyer, published by the Harvard University Press, was selected as a top 50 nonfiction book of the year by the Washington Post and was awarded honorable mention for the J. Willard Hurst Award by the Law and Society Association, as well as being a finalist for the Julia Ward Howe Book Award. He is also the co-editor of the book The New Black, What Has Changed and What Has Not with Race in America, published by the New Press in 2013. He has written opinion pieces for the Washington Post, the Boston Globe, the Los Angeles Times, the Huffington Post, the Root, the Baltimore Sun, and many other popular media outlets. In 2007, he was named an Alphonse Fletcher Senior Fellow by the Fletcher Foundation. During the 2008 and 2012 presidential election cycles, he offered commentary on a number of national television and print media outlets. He began his professional career as an electrical engineer at Bell Laboratories before turning to the law and to legal history. Before joining the faculty at Harvard Law School, he clerked for the Honorable Robert L. Carter in the United States District Court for the Southern District of New York and practiced law in the Washington, D.C. office of Covington and Berlin. About a decade ago, in fall of 2005, I actually took Professor Mack's course, Legal History, Historical Perspectives on the Role of the African American Lawyer, and it was just a life-changing course for me, so thank you so much for that experience, Professor Mack. And over the past decade, Professor Mack has been a wonderful mentor and friend, particularly when I was on the road to academia, so I'm very grateful to you for that as well. The title of his talk today is Rethinking the Role of Law in the Civil Rights Movement. And without further ado, Professor Mack.
Thank you, Professor Victoria Shannon, for that wonderful introduction. Thank you to Dean Dyer and Dean Twitty and the faculty at Washington Lee University and Law School for inviting me here. Thank you to all of you who have come today. Today I'd like to talk a little bit about the role of law in the civil rights movement, but in fact, actually, more specifically, the role of lawyers in the civil rights movement. I'm going to talk just a little bit based on my book, Representing Race, and highlight a couple of things that I first began to explore in the book. And what I'm going to talk about is the question of where do civil rights lawyers fit in the history of the civil rights movement, or more specifically, where do African American civil rights lawyers fit in the history of the civil rights movement. There's two familiar images of lawyers like Thurgood Marshall, Charles Houston, African American lawyers in the civil rights era. One image is the familiar image from Caroline Products, the image of lawyers as group advocates, as advocates for discrete and insular racial minorities. Second contrasting image, somewhat contrasting, not entirely, is the image of these lawyers as exemplars of civic virtue, not advocates for a group, but advocates for some values that characterize the profession as a whole. So today I'd like to do three things. We're sort of talking about how to think about these lawyers, an appropriate topic on Martin Luther King Day. I'd like to offer an account of what civil rights lawyers did, or what African American civil rights lawyers did in an era of segregation. I'd like to offer an account of how that idea works itself out in the career of one or two quite well-known African-American civil rights lawyers. And if I have time, we'll see how the clock goes. I might offer a few concluding thoughts on what all this means. I'm going to start by emphasizing that to understand the role of African-American lawyers in the era of segregation, we have to think of them first as lawyers. And think of them as practicing in a profession which placed demands on them and gave them opportunities. So first, I'm going to talk about what was distinctive about being a black lawyer in the era of segregation, or an African-American civil rights lawyer. And what was distinctive was the role of the courtroom. What was distinctive about being this kind of a person? Well, for that, we'd have to turn the clock back 80 or 90 years to the 1920s or the 1930s. This story is familiar to you. In the South, segregation prevailed. African Americans had been removed from the voting booth. They couldn't hold those jobs. And in almost every public place where people might interact across racial lines, blacks and whites are supposed to be separate. In the North as well, in places like Philadelphia, elementary schools remained segregated, though contrary to established law. It was hard to get a seat on a first-class train in the streetcars in downtown. You can't, if you're an African American, you couldn't stay in any of the hotels downtown. You couldn't attend any of the theaters. You couldn't get served a meal anywhere in downtown Philadelphia. This was the world of segregation, where blacks and whites were supposed to be separate in all public spaces. But what I'm going to suggest to you today is that the courtroom was just a little bit different, actually radically different than the world I've just described. Courtrooms played a unique role as segregation began to extend its tentacles to the north as well as the south. Unique because, well, there was only one kind of courtroom. Courtrooms were not segregated. If you were a lawyer, black or white, you were expected to come to court and do the same thing that other lawyers did. Courts were public spaces. They were places where people interacted in public across racial lines in an era in which such spaces were limited north and south. In most public places, people did not interact across racial lines in public, but courtrooms were different. As a matter of fact, black lawyers, even in the era of segregation, went to court. They went to court in every part of the country. And in every part of the country, they talked about how going to court was very different than anything else that they did. Louis Redding, for instance, the first and only black lawyer in Delaware, began practicing in 1929, said, quote, "I can honestly say that I've never encountered from any judge any overt display of racial prejudice," close quote. A black lawyer in Jackson, Mississippi in 1930 would say this, quote, "Negro lawyers, of course, actually try cases here in court almost daily, and white and colored lawyers work amicably together in the same case." Now, not to sort of overemphasize the seeming optimism of such comments, but just to emphasize that black lawyers, if you asked them, in all parts of the countries, noted something different about going to court, and noted that going to court was a less discriminatory space than doing just about anything else. In fact, in court, things happened that did not happen other places. One of the first things I came across when I started researching this project was a trial transcript. It's a trial transcript of a cross-examination that's happening in a courtroom in Philadelphia in 1944. The lawyer doing the examination is a lawyer named Raymond Pace Alexander, who was the leading African-American civil rights lawyer in the city at the time. And he was examining a detective in a criminal case. And he's browbeating the detective. And the detective starts to go, "Yes, sir. No, sir. They didn't find anything there, Mr. Alexander." And it seems just kind of reads like any old trial transcript. This is what lawyers do, right? They cross-examine people. Sometimes they browbeat them. But to understand the significance of this moment, you have to understand that 100 feet away, just outside the courtroom, the courthouse in downtown Philadelphia, Raymond Pace Alexander cannot be served a sandwich. He cannot get anything to eat. He can't go to a restaurant. He can't do anything that white people do. Whereas the detective who is cross-examining can do these things as a matter of course. Something different went on inside the courtroom. Right? Something that was different than any other thing that would happen in downtown Philadelphia, which is that Raymond Place Alexander got to interact with a white person in public as an equal. Actually, indeed, as a superior, which was the most distinctive thing about his life as a lawyer. As a matter of fact, when I sort of talk about the role of the courtroom, why were courtrooms different, I'm deploying a particular idea of what was racial identity in an era of segregation. What was racial identity even in the era of the civil rights movement? Well, for this I turn to a quote by W.E.B. Du Bois, who said, quote, "I recognize black quite easily. The black man is a person who must ride Jim Crow in Georgia." What's Du Bois saying? Well, public space makes race. I don't know who's black or white, but you got to ride a segregated car in Georgia, they're going to sort it out. Race is defined by who does what in public spaces. Most black lawyers in the country in this period practiced in northern and border state cities, places like Philadelphia, Washington, D.C., Baltimore, Chicago, St. Louis, a few in the Deep South. These cities were the places where racial identity was being heightened as segregation began to be extended to places like schoolhouses, public accommodations. But courtrooms were the only place that was different. Now, when I talk about someone like Raymond Alexander, or as I'll say later in the talk, Charles Houston or Thurgood Marshall, going to court being treated like an equal, I'm talking about a formal equality. I'm just talking about sort of how people treat you on a very formal level. I'm talking about forms of address, patterns of deference, professional acts, right? When you went to court as a black civil rights lawyer, they had to treat you more or less, most of the time, like a white lawyer, formally at least. Everyone understands that there's discrimination against courtrooms. In courtrooms, everybody understands that people don't think of Raymond Pace Alexander or Thurgood Marshall as an equal of their white counterparts, but they have to treat them like they're the equal. And that's the key for understanding the argument that I'm going to make today. As a matter of fact, the most striking example of this phenomenon occurred in a case that will be familiar to all of you, Brown versus Board of Education. When the Brown litigation reached the Supreme Court, the two principals on the two sides of the case were Thurgood Marshall, of course, the chief lawyer for the NAACP, and John W. Davis of Davis Polk, the New York law firm, an eminent patrician white Southerner who was perhaps the most prestigious lawyer in the country. John W. Davis was also a believer in segregation. So what did Thurgood Marshall do when he and John W. Davis were going to face each other in the Supreme Court? Well, Marshall's deputy, Robert Carter, another black lawyer, Marshall's number 2 at the NAACP, later confessed that he was perplexed by what Marshall did when he had to face John W. Davis. Because the first thing that Marshall did was took John W. Davis to lunch. And Carter would say, why? Or why are you going to lunch with the enemy? In fact, with a believer in segregation. As a matter of fact, it went further than this. According to Davis's biographer, during both the first and second Supreme Court arguments in Brown, Marshall and John W. Davis sat near each other in the back of the courtroom, sort of one-upping each other, sort of exchanging asides and jokes and pleasantries. And Davis did this with Marshall despite his belief in segregation, despite what Davis referred to as the, quote, anatomical and intellectual, close quote, differences between blacks and whites that made segregation something that was necessary. Well, necessary except if he was facing a black lawyer. What's Marshall doing? Well, Carter later provided a hint. He said that Marshall told him, quote, "We're both attorneys. We're civil. It's very important to have a civil relationship with your opponent." What Marshall was really doing, he was making a point. We're both lawyers, and he was using his identity as a lawyer to wring something from Davis that Davis would never give an African American outside the context of courtroom litigation, which was to be treated as a relative equal. In fact, Davis would die within a year of the Brown decision, convinced that his world was slipping from his grasp, seemingly unaware that the interaction between himself and his black adversary was a sure sign of that slippage as anything else. So that's the role of the courtroom in the era of segregation. Everybody understands that courtrooms are rife with segregation. I am not saying that there was no segregation or discrimination inside the courtroom. But what I am saying is that black lawyers, north, south, east, and west, constantly say that they're being treated fairly in the courtroom, over and over and over again. What do they mean by this? What they mean is, within some limits at least, the treatment that they received in the courtroom was distinctive. It was different than what happened everywhere else. And they were taking note of that distinction. Now, what happened in the courtroom was, it was really a script. Everybody started sticking to a script, right? There's a way in which you address a lawyer, and they have to address the black lawyer, more or less, with some actually notable limitations, more or less the way they have to address a white lawyer. In fact, when there were departures from this script, those departures would provoke outrage among the black bar. Take Dallas Nicholas, for instance. Dallas Nicholas is a Baltimore lawyer, an African-American lawyer practiced in Baltimore in the 1930s, 40s, and 50s. You've never heard of him. Nobody's ever heard of him. There's good reason. Dallas Nicholas, he was just scratching and scraping, trying to survive, doing his cases, barely making a living in the practice of law, not complaining about life, just trying to get along as a lawyer. You've never heard of him. But the one moment, one goes through Dallas Nicholas's papers as I have, the one moment where you saw fire from Dallas Nicholas was a moment when he heard a local white lawyer use the term darky in the courtroom. He wrote this lawyer an angry letter saying, "We're all human and entitled to courtesy and respect." It's the one thing that could rouse Dallas Nicholas out of his seemingly just sort of get through everyday approach to being a lawyer. A departure from the respect that he expected African Americans to receive inside the courtroom. And in fact, practically the entire African American bar erupted in outrage in the late 1930s when a Pennsylvania judge sentenced a black youth for attempted seduction of two white girls, and said if the authorities had, quote, if, quote, they had lynched you, they would have been justified. The entire black bar erupted in outrage. The National Bar Association, the Black Lawyers Professional Group, organized in response to this insult. They coordinated with the NAACP. They lobbied the Pennsylvania legislature to impeach the judge, and threatened with impeachment. They forced an admission out of the judge and an apology. Admission that he had done wrong and an apology. The script inside the courtroom was very important to these lawyers. Courtrooms were the most distinctive places in their lives. Why so? A couple of different reasons. One, these lawyers were repeat players. Early 20th century legal communities were small communities by our standards, even in places like Philadelphia and Chicago. If you go through a lawyer's papers, you will see the same opponents show up over and over and over again. Lawyers knew one another. The same judges show up over and over and over again. Early 20th century legal communities were small communities by our standards. Lawyers were repeat players. They would encounter the same opponents over and over again. They got used to one another. They knew one another. And for a black lawyer, it was possible, with some limits, to be treated sort of like a white lawyer. You couldn't always join the white bar, but you could be, in some measure, inducted into the white legal fraternity, as I'll explain in greater depth shortly. This happened to many, many lawyers, among them Raymond Pace Alexander, the lawyer I mentioned earlier, the Philadelphia lawyer, who would just encounter the same opponents over and over again. A young lawyer named Michael Musmano, who he encountered when he was clerking, would go on to be a Pennsylvania Supreme Court justice. And the two would write to one another over the course of their careers. An opponent in one case would become an ally in the next. So the script that I'm talking about, the way the courtrooms work for black lawyers, the thing that made them distinctive, had its source in part in the fact that to be a lawyer in this context was to know a community and to encounter the same people within the community over and over again. As a matter of fact, this phenomenon was key to the career, key to the rise to national prominence of a young lawyer named Thurgood Marshall. Thurgood Marshall made his early career in Baltimore and in rural parts of Maryland by taking on ordinary cases, taking on civil rights cases, taking on criminal cases, and often showing up in a place where nobody had ever seen a black lawyer before. Marshall would show up, people would have to figure out how to treat him, and Marshall, through repeat encounters with the same judges, the same lawyers, the same opponents, would develop relationships with them. And as I say more fully in the book, over time, when Marshall showed up in court, local white lawyers and judges out in rural Maryland, they weren't apprehensive, they welcomed him because Marshall developed a power through his repeated encounters with the same opponents and the same judges. If Marshall said a trial was fair, it was fair. Everybody understood that if Marshall said it was fair, that was it within the local black community. As a matter of fact, there was one trial where it was an interracial rape prosecution of a black defendant where apparently the trial lasted 12 minutes. 12 minutes, but Marshall said it was fair. And when Marshall said it was fair, that was the end of the debate. Everyone understood that it was fair and they could move on. When Marshall said it was not fair, that was another thing entirely. In one of his early cases, one of the cases that really made him, involving a shooting of a black motorist by a white police officer in Bladensburg, Maryland, which at that time was a kind of rural, kind of white supremacist territory, lots of violence against black motorists who were coming through by the local white police force. A shooting of a black motorist by a police officer in Bladensburg, Marshall commenced a civil suit against the police officer and got a $5,000 verdict in a place where black people had no power, had very little political purchase, and a place where violence against African Americans was actually quite commonplace. How did he do this? Well, he did this because he knew the judges there, he knew the lawyers there, and the judges and lawyers strategized with Marshall to get a verdict. So when Marshall said something was not fair, everybody understood that it was a problem. So, this is the world I'm beginning to sketch for you. A world in which courtrooms are very distinctive. They're different than every place else for black lawyers. They're different than every place else for the particular kind of interaction I'm describing. A place where black lawyers like Thurgood Marshall make their careers by facing the same opponents over and over and over again. And it's a place where black lawyers and white opponents develop a script, right? A script that enables things to happen inside the courtroom that don't happen anywhere else. Well, there's one particular exception to this world I've just sort of sketched out for you. The exception is the major civil rights case. As late as the 1930s, when it came to major civil rights cases, for the most part, black lawyers didn't do them. White lawyers did. As a matter of fact, the leading civil rights organization in the country, the NAACP, would only employ white lawyers for its important litigation. A black lawyer might take a case in the early stages, in the trial stages, but once it went to appeal, once it became a more important case, the NAACP expected black lawyers to step aside in favor of their white counterparts. Or perhaps if it was a very, very, very important trial, the NAACP would ask the black lawyer to step aside at the beginning in favor of a more experienced white lawyer. And all this made sense. I mean, it's a world of segregation, a world of prejudice. You expect courtrooms, despite what I've just described, to be very prejudiced places. And if you have the choice, and you were the NAACP, of course you would prefer the white lawyer. And of course, well, not only could they prefer the white lawyer, but they could get some of the best lawyers in the country. The white lawyers who did the NAACP's civil rights litigation were people like Clarence Darrow, Arthur Garfield Hayes, Moorfield Story. These are some of the most prestigious lawyers in the country. But by the early 1930s, this generation of white lawyers who had done civil rights cases was aging and dying, and black lawyers wanted to take over. But nonetheless, for the NAACP, this kind of a job was still the job of white lawyers. There was resistance even among the black NAACP staff to hiring black lawyers to take on major civil rights cases. What these black lawyers needed to extend the world that I've just talked about, the world in which the courtroom was a place of relative equality. What they needed was a major case that would show the NAACP and the rest of the world that a black lawyer could come to court and do the kinds of things that I've just described in a major civil rights case, and win the case. And that case arrived in 1933 and happened right here in Virginia, in Loudoun County, in a case in which a black man named George Crawford was put on trial for a double murder. Okay. The George Crawford trial would open up a new public space, the space of the civil rights courtroom, to black lawyers. And it did it this way. George Crawford, in early 1932, was indicted for a double murder of a white socialite and her white maid in Loudoun County, Virginia. A manhunt ensued for Mr. Crawford, and he wisely escaped the county because there were rumors, there was a wide expectation that if he remained in the county, he would have been lynched before coming to trial. A national manhunt ensued because the person he was accused of murdering was a white socialite with a national reputation. The case made the New York Times, the Washington Post, the national media followed it closely. A national manhunt ensued, which finally netted George Crawford in Boston in January of 1933. Crawford wisely sought the assistance of the NAACP. The NAACP fought his extradition to Virginia, claiming that if he was put on trial in Virginia, two things. Well, one, that his life remained in danger if he were sent to Virginia. And second, if he were put on trial in Virginia, the trial would be unconstitutional for various reasons that I'll go into in a second. But after going up to the Second Circuit, there was finally a ruling that Crawford had to be extradited to Virginia. So the fall of 1933, George Crawford would go on trial for a double murder in Virginia. But at this moment, the thing happened. The case was already famous. It was already being followed in the national media. The extradition fight had ramped up the profile of the case. It was being followed by members of Congress. But the thing that really ramped up the profile of the case was the thing that made it the most unusual, is that the NAACP decided to send in a black lawyer to defend George Crawford. And the lawyer they sent in was a lawyer named Charles Hamilton Houston. And this would be Houston's first major NAACP case. This would be the first major NAACP case where the organization would send in a black lawyer. And the case would make or break the reputation of black lawyers in civil rights cases. As many of you may know, Charles Houston was quite well known. He was a 1922 graduate of Harvard Law School. He returned to get a SJD, equivalent of a PhD in law from Harvard Law School. He was the vice dean or de facto head of Howard Law School, where they trained lawyers like Thurgood Marshall. But nonetheless, the NAACP was frightened to send him in to Loudoun County, Virginia, to defend George Crawford, and for good reason, because Houston's entry into the case raised an issue. How should a black lawyer be treated in a southern courtroom in a place where nobody had seen a black lawyer before? Southern courtrooms were segregated space. The formal space of the courtroom, the place where judges and jurors sat, was reserved for whites only. When blacks entered that formal space as witnesses, litigants, or defendants, they had to be addressed by their first names. Deviations, that was the script. If you were African American in a courtroom, you were supposed to be addressed by your first name. But if you're a lawyer, you were supposed to be addressed somewhat differently. What were they supposed to do? And in fact, deviation from the script could produce violence. For instance, in the famous Scottsboro Boys case, where the 9 black youths were accused of raping 2 white women in Alabama, if you'll recall, the second time they go on trial, Samuel Leibowitz represents them. Samuel Leibowitz, a famous New York lawyer. Well, Samuel Leibowitz was a famous New York lawyer. You can tell by the name Leibowitz, his name elicited some controversy in Alabama. But the thing that elicited the most controversy when Samuel Leibowitz went in and did the second Scottsboro trial was one sentence that he uttered. Early in the trial, the prosecution called a black witness by his first name. And Leibowitz interrupted and said, quote, "Call him Mr. Sanford, please." And from that moment, Leibowitz's reputation begins to go down in the local community. And it becomes clear that the second Scottsboro trial is going to be a replay of the first, and the community is just not going to give an inch. So you deviate from the script of how African Americans are supposed to be addressed in the courtroom, there was a lot to pay, put it that way. So what were we supposed to do? What was anyone supposed to do in Loudoun County, Virginia, when a black lawyer, Charles Houston, shows up to defend George Crawford? Well, nobody really knew. Nobody ever could remember a black lawyer appearing in Loudoun County courts, in the Loudoun County courts before, because there were no black lawyers in Loudoun County. As a matter of fact, the only black professional in Loudoun County was a black doctor. There was no constitutional right to practice law, but many southern communities had invoked custom, right? Remember I said black lawyers said that they were treated fair in court in the places where they practiced, but there were many places where they simply didn't practice. Many local communities invoked custom to prevent black lawyers from practicing at all. Crossing that line could bring violence. And in fact, an appearance by a black lawyer was so striking that an entire community might come out to watch. For instance, Constance Baker Motley, black woman lawyer who worked for the NAACP, very famous. She was a federal judge, passed away a few years ago. Constance Baker Motley remembered in the 1940s when she and Robert Carter went south to Mississippi to try a school desegregation case. What she said was the most striking thing about the case was the community's reaction to her and Carter simply coming to court. She said the local African Americans thought it was, quote, the greatest thing that had happened in Mississippi since emancipation to see Carter come to court and cross-examine the local white superintendent and tell him to speak up loudly. I can't hear you. These were things that black people just didn't get to do and say in Mississippi. But they got to do and say it when black lawyers showed up. The arrival of an African-American lawyer in a civil rights case was a civil rights claim in and of itself. It raised a question, well, did this professional role that crossed racial lines, sort of here and there, north and south, in non-civil rights cases extend to a major civil rights case, even in a place where nobody had ever seen a black lawyer before? The role of the lawyer should, the script that I'm talking about, the script that attaches to being a lawyer, should extend across racial lines, at least if you could pull it off. And nobody knew whether Houston could pull it off. Houston would come to Loudoun County twice to defend George Crawford. He came first in the summer of 1933 with a motion, a very controversial motion, as you'll see for reasons I'll make clear in a second. A very controversial motion. He came first with a motion arguing that the indictment of George Crawford for the double murder of the two white women was unconstitutional because African Americans had been excluded deliberately from the grand jury that indicted George Crawford. The New York Times reported that, quote, 600 spectators, half of whom were Negroes, filled every available seat in the courtroom while scores of others milled about the courthouse when a black lawyer came to Loudoun County to defend George Crawford. And the people who came there saw something the likes of which they had never seen. Houston's principal witness, a hostile witness, this principal witness in arguing and challenging the selection of the grand jury that indicted George Crawford was the local circuit judge, a gentleman named J.R.H. Alexander. Because Houston was arguing that there had been race discrimination or racial exclusion, for that matter, in picking the grand jury, and Judge Alexander had picked the jury. So the local judge is the first person Houston puts on the stand when he arrives in Loudoun County. And everybody wonders, how's this going to go? The local judge was a very, very well-respected man. I mean, Loudoun County sort of was kind of, not really quite anymore, but sort of was horse country. Horse country. It had a kind of gentleman fox hunting set. Judge Alexander was sort of he was the epitome of this. He was a gentleman. He was a member of the ruling class. So what does Charles Houston do? Well, first he requires Judge Alexander to disqualify himself from hearing the case because he's going to be cross-examined. They bring up another judge, a judge named John McLemore, to hear the case. And he puts Alexander on the stand. Not only does he put him on the stand, but he kind of browbeats him a little bit. He peppers him with questions like, did you or did you not consider the Negro population in picking juries? And in fact, in his closing argument on his grand jury motion, he hammers away at the judge's veracity. Right? This is the most prestigious lawyer or judge in the county, actually in the 3 surrounding counties. He hammers away at him, all but calls him a liar. He calls him a slow and reluctant witness. The Washington Post reports that Houston asked 2 questions. Were there qualified blacks, and were they excluded because of their race? And that Houston, quote, shouted affirmative answers to both questions. He argued that Judge Alexander, quote, has been revolving around in a closed circle, a wheel excluding all Negroes. In other words, a caste system is prevalent in Virginia and in the South. These are fighting words to be said in a Loudoun County courtroom, fighting words to be said in describing the pillar of the legal establishment in the county. But the odd thing is that local whites never really perceived them that way. Even though Houston made it clear, announced in public, that if he lost his grand jury challenge, he was going to take it all the way to the Supreme Court, that he would put African Americans on grand juries in a county that was determined to prevent that practice. But nonetheless, everybody experienced his arguments as reasonable. As a matter of fact, one local white man, when asked about the appearance of a black man in the local courtroom, says this: "You've got to give it to him. He knows what he's doing, even if he is a nigger." this is how whites experience, yes, he was that, but somehow he's a lawyer too. Houston's performance was both radical and respectable. The only thing that enabled whites to accept it was the thing that I described earlier, this sort of script that applies inside the courtroom. Houston was able to sort of fold himself into the local bar and get local whites to see him kind of, sort of, not entirely, but like a white man. In fact, that process of seeing him like a white man was reinforced at the trial. Houston lost his grand jury motion, as you might expect. Judge McLemore ruled that there had been no racial discrimination of the grand jury, so they went to trial. At trial, there were basically kind of several big issues. One, Houston was going to attack racial exclusion in the Pettit jury that would try the case. Second, Houston was expected to argue that George Crawford was not even in Virginia at the time of the double murders, that he was in Boston. Third, the only real evidence the prosecution had of the crime was a confession that Crawford purportedly made while he was in jail in Boston awaiting extradition to Virginia. The local Virginia prosecutor, a guy named John Gallagher, traveled to Boston and obtained what he claimed was a signed confession by George Crawford to the double murders. But the confession was a little odd. The confession has two parts. First part of the transcript, the prosecutor is browbeating Crawford, and Crawford is vehemently denying his guilt, saying, I wasn't there. If anyone says I was there, they're a liar. And if there's a pause in the transcript, and the transcript begins again, and the first question is, are you ready to confess to the crime? Crawford says yes. So the question that's raised in everyone's mind is sort of what happened between these two transcripts that was not transcribed and induced Crawford to change his story. Houston's basic argument at the trial was going to be that the confession was coerced, that the prosecutor had done something illegal to get the confession, and therefore the confession should not be admitted into evidence. Right? These were going to be the issues of the trial. Was Crawford in Virginia? Was the confession a valid confession? And in fact, Houston was expected to cross-examine Gallagher himself, the local prosecutor, just like he cross-examined Judge Alexander about what he actually had done to get the confession. Well, something happened between the grand jury motion and the trial. First, Houston came to doubt his client's guilt. He came to doubt his client's innocence. He came to believe that George Crawford at least had been in Virginia at the time of the murders and didn't have an alibi. And second, he found himself kind of drawn into the local bar. They began to treat him with an unusual degree of professional camaraderie. As a matter of fact, it happened right at the start of the trial, when the trial judge, John McLemore, who had been brought in to replace Judge Alexander. John McLemore took note of how Houston was being described in local media. There was a local newspaper story that said that Houston brought in sort of an all-black defense team. He brought in one of his fellow professors at Howard Law School. He brought in 2 Howard Law School students. These were the 4 black lawyers who were defending George Crawford in Virginia. A local newspaper had reported that the black lawyers had better be careful the way with what they said in court, or there might be violence. And Judge McLemore announced at the beginning of trial that he would have none of it. He said the Commonwealth and the defense have the same rights in the courtroom. And if they, the black lawyers, the 4 black lawyers on the defense team, the likes of which nobody had ever seen in the county, if they conduct themselves properly, I have no doubt they will be treated exactly like white men. So what McLemore was saying was, if they kind of adhere to the script that applies to lawyers, we will treat them like white men. And McLemore more or less set the script for the entire trial. In fact, during the entire trial, Houston was treated with a remarkable degree of professional respect and deference. The prosecution was quite methodical in its presentation of evidence. There was none of the kind of race-baiting or evocation of white womanhood that everybody expected. Charles Houston was actually quite deferential to his white colleagues. He was actually a little bit too deferential in the eyes of some people. He let Gallagher put on a lot of witnesses, saying that Crawford had been in the county at the time of the trial. He didn't cross-examine or try to rebut the evidence. He didn't, as expected, argue that Gallagher had done something incorrect, illegal to get the confessions. He sort of just argued that the confession was unreliable and shouldn't be admitted into evidence. In fact, on the question of George Crawford's guilt or innocence, Houston seemed to be sending every signal that he had doubts about his client's innocence, or at least he didn't have a lot of evidence to refute the prosecution's evidence of his guilt. With regard to the lawyerly interactions, however, it couldn't have been different. Houston aggressively and continually showed up his white colleagues. Right? He would interrupt Gallagher's examinations of witnesses as duplicative. He interrupted other lawyers as duplicatively objected to relevance of evidence. At one point, he was filing a motion challenging the race discrimination of the Pettit jury, and he called one of the jury commissioners. He presented him with a list of the putative jurors, and turned out the jury commissioner couldn't read it because the jury commissioner couldn't read, and then Houston proceeded to sort of read the list himself. Right? So did all these sort of subtle and not so subtle things to show that he was the smartest lawyer in the courtroom, and most people thought that he was. Well, at the end of the trial, something unexpected happened. The prosecution, as expected, got its guilty verdict. Right? The jury found George Crawford guilty. But contrary to expectations, they sentenced him to life imprisonment rather than the death penalty, which everybody thought was going to be the result as a matter of course in the case. And the jurors, actually interviewed after the trial, said that actually it was Houston's presentation, his lawyerly presentation, that convinced them to grant clemency. Well, what happened after the trial was almost as interesting as what happened at the trial. Houston, as I said, early 20th century legal communities are small. People kind of sort of show up again and again, and Houston showed up again and again in Loudoun County. Everybody got to know one another. In fact, at the beginning of the trial, Houston thought that the trial was going to be a battle, but by the time it was over, he had been somewhat folded into the local legal community and treated, as Judge McLemore had indicated, like a white man. So Houston became, and afterwards Houston became a repeat player in local legal disputes. When local African Americans wanted to challenge the conditions of their segregated school, and they wanted either better school facilities or an equal school, who did they call but Charles Houston to represent them? And Houston, without even having to file any pleadings, got the local authorities to upgrade the conditions of the black school. When, more controversially, when there was an interracial rape case a few years later in Loudoun County, the kind of case that everybody thought couldn't be won, certainly couldn't be won by a black lawyer. A black man was accused of raping a white woman. Houston was brought in. The judge was J.R.H. Alexander, the same person who he had cross-examined in the courtroom a few years earlier. The local prosecutor, of course, he knew. And all these lawyers doubted that this guy was guilty. And they all basically conspired with Houston to, that he was convicted after trial, but they conspired to Houston to get it before the Virginia Supreme Court in such circumstances as the Supreme Court would overturn the verdict, and they got the black defendant out of the county before he could be lynched. So Houston became a familiar figure in Loudoun County. He sort of showed that black lawyers could, produce the same script in civil rights cases they produced in other cases. He became a repeat player. People knew him. When Houston showed up, they had to actually give him a degree of respect. When Houston showed up and asked for something, the local white lawyers and judges were sometimes, not always, on his side. This is the key to Houston's career. This is how Charles Houston became Charles Houston. He became the first African-American lawyer to be the head of the NAACP's legal team. Actually became the first full-time lawyer to work for the NAACP. And in a few years, they would bring his protege, Thurgood Marshall, whose career had taken almost exactly the same kind of track through repeat performances, the same opponents, adhering to the lawyerly script. He would be able to promote Thurgood Marshall as his replacement. So as I said at the beginning, this is a testament to the power of the courtroom in the lives of African Americans living in the era of segregation. What was possible to get out of lawyerly interactions inside the courtroom. How lawyers like Houston and Marshall were able to mobilize the script to get things out of the system. They conceded things as well, as some of you may note when we come to a little short Q&A period afterwards. They conceded things as well. But the distinctive nature of the courtroom, the lawyer interactions, and the ability of lawyers to transcend racial boundaries inside the courtroom was an advantage. And it was the key to the rise of lawyers like Thurgood Marshall and Charles Houston. And it was at least part of the reason for their successes at the practice of law. Thanks.
Professor Mack is going to take a few questions. Does anyone have a question for Professor Mack?
It sounds to me that as soon as Charles Houston was getting the respect from his white counterpart, he lost sight of what his mission was, which was to advocate for his client, the respectability. And what is your opinion on that?
Yeah, that's
a to doubt
yes.
his client's innocence.
Yes. This is a complicated question. Well, some people thought it was easy, some people thought it was complicated. As a matter of fact, there was a 2-year debate that played out in the pages of black newspapers all over the country after the case about whether Houston had done exactly what you said. A bunch of people wrote in to say that he did not advocate zealously on behalf of his client. Other people wrote in to say that this case was a triumph. There's a couple of ways of reading the case, and I always think that this would be a great sort of professional responsibility case. There are a couple of ways of reading the case. One is that Houston conceded that he was not likely to get that a not guilty verdict was unlikely. And he tried to figure out what he could get out of the system. And what he could get out of the system was a life sentence, and the price for a life sentence was perhaps not being as aggressive as he otherwise might have been. The second thing is that he had to worry. The second thing he did is he didn't appeal. The other thing to note, he has 2 appeal issues. One is that race discrimination in the grand jury, and they put a lot of evidence in. It's hard not to face up to the fact that this is occurring. Second, race discrimination in the appellate jury, again, they put a lot of evidence in, hard to face up to the fact that this is not occurring. These are likely winners on appeal for a bunch of different reasons. But if he brings the appeal and he wins, what he gets is not his client going free, he gets a new trial. And he's not going to get the same result in the second trial. But so one reading of the case is that Houston decides what he can get out of the case, given that his client is likely to be convicted, and he gets that out of the case. The second reading of the case is that the price of the power that Houston achieved inside the courtroom, that there was a price. The price was zealous advocacy on behalf of his client. That's not an unfair reading of what he did. Or to state it in more general terms, that perhaps what he is doing is he's creating an advantage for himself and lawyers like him in subsequent cases by not going as hard as he could on in this case, right? It makes it more likely he's going to win the later cases, even though it makes it less likely, well, maybe less likely he's going to win this case, right? That's the second way to kind of think about it. And the third way to think about it is that he just got sort of sucked in, that, you know, the kind of lawyerly interactions I'm talking about are kind of a double-edged sword. And, you know, and to some extent, you can get sucked in by the distinctiveness of what happened in the courtroom and lose sight of the necessary thing that Houston did concede that you had to do, which was represent your client zealously. So I think all three are possible readings, and I try not to make a definitive statement about which one of those things is true. But a lot of people after the trial said exactly what you said. And Houston had a 2-year argument with his opponents in the pages of the black press about this case and about whether or not he had sold out his client. As a matter of fact, a bunch of people thought that he should not be promoted to the lead lawyer for the NAACP precisely because of what happened in this case. So, thank you. Sure.
In some of your previous talks, you've talked about how early civil rights lawyers were considered as representative black men or women.
Mm-hmm.
How do you think that idea has either changed or stayed the same, or has that affected as race relations between lawyers presently?
Yeah, this is a kind of core argument in my book that, you know, that the lawyers became what I call representative black men or representative black women. And as, you know, the first question, this is kind of a double-edged sword, right? That both blacks and whites wanted them to do the exact kind of thing that Houston did in this case. They wanted them to be accepted by white lawyers. Both blacks and whites wanted them to be the opposite. They wanted them to be kind of, you know, rebels. They wanted to be kind of, you know, group advocates against the power of the white legal system. And, you know, in representation, I'm saying it's both things. It's being both like and unlike the white lawyers around you. The specific argument, right, so that I'm a historian, so I have to kind of say this is a little bit about the past, right? So the particular things I'm talking about that produce this problem of representation no longer exist. We no longer live in a segregated society. We no longer live in a society in which a black lawyer going to court is such a distinctive experience. Although, as you are kind of hinting at, I am kind of hinting that this problem of representation continues. It's perhaps the problem of minority group representation writ large, right? That the surest entry into the system, the power structure, particularly for lawyers, for representatives of minority groups, is to be like the larger society or like the elite actors in the larger society, but at the same time you are supposed to represent the group in the other sense of the word representation. And what I'm really saying in the book is that this is sort of a paradox, right? There's no escape, there's no right answer to this, right? It's just a question that we struggle with over and over again. Oh, so I think we have like 1 more minute or something like that. Sorry I went on for so long. We might have time for one more question. Victoria can tell me when we have time for more than one.
It's a related question to the last one. A lot of people say that the low moves very slowly, and especially in relation to the world at large. But from what you're saying about the legal community and the acceptance of black people into it, it seems like maybe there's a disparity there, and that maybe that space, the courtroom, was ahead of the outside world. Why do you think that is?
A couple of reasons. I mean, one is that, you know, the way I describe it, the courtroom is a very specialized space, right? It has its own rules. The lawyers all understand that it has its own rules. Second, there's no segregated courtroom, right? You can have two court systems, you can have two everything. You can't have two court systems, right? You've got to have one court system. And when you have one court system, there's supposed to be one set of rules for everybody. And, not exactly one set of rules for everybody, but that's the kind of nature of segregation. This is one space that cannot be, of course courtrooms are segregated in certain senses, right? The black people have to sit in different parts of the courtroom in various parts of the South. There's places in the South where black people have trouble practicing law, but there are other places where black lawyers say, we practice law every day. Galveston, Texas is one of these places. There are all these sort of unlikely places where black lawyers come to court all the time. So some of it has to do with the nature of the courtroom and the nature of professional interactions and why those are different than interactions in other places. And the second is just, the nature of segregation. This is one space that simply can't be segregated, or it's really hard to segregate it. And because of that, it presents a certain opportunity that's not present anywhere else. You can tell me if we're done.
Oh, we have one more? Do we have time, Brett?
Yeah.
We have one time? Okay, go ahead.
This is just a point about the first question. What counts as a success or a victory? What's the scale here, right? I'm reminded of isn't it that in To Kill a Mockingbird, Finch says that the success was that the jury deliberated before the conviction, right? That would not have happened, but he got them to at least, and there was one holdout, and he voted in it. So, I'm still curious as to what, if it was the case that this was done, with the intention, the goal of some kind of reform, right? Well, we get these victories, i.e., not the death penalty, and we have a plan, and this is to eventually, I'm going to work on making the community more accepting of black lawyers, and eventually there'll be justice for blacks, right? That makes some sense of it. But I mean, if the idea is for here and now we're going to get this modest return of a life sentence, admittedly there's this complication, does he believe the guy is guilty or not? But it's assumed that the strategy, it seems, is the same regardless of guilt or innocence, just to get the conviction of a life sentence without a death penalty. I mean, that seems to me to be, unless it's this plan, that why would one celebrate that?
Okay, how to answer this? I've kind of deliberately not tried to take a position whether or not this is a success or a failure. It's kind of both, right? But let me give you sort of two or three things. I mean, one is that afterwards, how does Houston defend himself? He comes under a lot of criticism for doing this. And he writes an article saying this is an example of what he calls social statesmanship. He says two or three things. He says without saying it, because he can't say it because he's too good a lawyer to say it. He says that his client is guilty without saying it, but he clearly believes that his client is guilty. Now, that doesn't absolve him of the obligation to represent his client zealously, and he concedes that. But he's saying, Crawford got a fair shake. That's what he says. Second, he says that the trial was an example of social statesmanship, meaning the kinds of things I've just identified, that he's won allies within the local county. Judge McLemore, at the end of the trial, says we should call black people for jury service. Do they do it? It's kind of complicated. How does this really happen? But he does get local white leaders after the trial to say we should put black people on juries. Third, he builds up support for the NAACP. Not only in the local community, but there's a guy who becomes his ally because of this case. This guy named Virginia Dabney. He's the editor of the Richmond Times-Dispatch. He writes a book called Liberalism in the South. He's a complicated figure. But he sees himself as a Southern racial liberal, although he's not. He's a moderate. No, he's a moderate. And Dabney becomes the ally of the NAACP because of this case. So when Houston wants to get good publicity for one of his cases, but he's trying to mobilize white opinion in favor of something, Dabney will run articles in the Richmond Times-Dispatch, which is the most influential newspaper in Virginia at the time. Oh, there's two. There's the Richmond News Leader. There's the most influential newspaper in Virginia will sometimes do things to support Houston's cases. So he counts all these things as elements of social statesmanship as victories. You all have sort of said, parts of why perhaps these are ambiguous victories at best. But he is saying, I am building professional capital to be used in the future, and I'm going to come back and use it. He is saying, there are problems with my client's case, and there were problems. The other thing that makes the case so complicated is that if you really believe what Houston believed, to do certain of the things he originally planned to do at trial, he had to ask himself if he was putting on perjured witnesses. If someone says Houston was in Boston, and Houston believes that the person is lying, should he put the person on? Right? So there are all these sort of complicated questions that swirl around the trial, but I don't know if any of them really resolve, at least as neatly as Houston wanted to resolve it, the question of whether or not he had aggressively represented his client, or at least if he had been as aggressive as he needed to be. And I think the best reading of the trial is that he sacrificed certain things, certain immediate goals for more long-term goals. And whether or not you think this is a success depends on how you feel about that as a strategic move.
All right, so join me in thanking